Hello everyone, my name is Amit Jyoti. I am an assistant professor at the O.P. Jindal Global University. In this module, we shall be talking about the regional human rights system in the Americas. In the Americas, the regional human rights arrangements exist within the intergovernmental organization known as the Organization of American States or OAS. This organization was established in order to achieve among its member states, as stipulated in Article 1 of the Charter, an order of peace and justice to promote their solidarity, to strengthen their collaboration, and to defend their sovereignty, their territorial integrity, and their independence. Two organs of this organization that are central to the enforcement of its human rights regime are the Inter-American Commission on Human Rights, referred to as IACHR, and the specialized organization known as Inter-American Court of Human Rights, that is IACTHR. The OAS Charter established the IACHR way back in 1959, whereas the IACTHR Court was established much later in 1979 after the American Convention on Human Rights entered into force. Let's now talk about American Convention on Human Rights. The American Convention on Human Rights is divided into three parts. Part 1 deals with all the rights that are protected under the convention and all the state is obligated to do. Part 2 lists out provisions that govern the setting up and functioning of both IACHR and the Human Rights Court. Finally, Part 3 deals with general and transitory provisions which are not covered elsewhere in the convention. You may refer to this convention for a detailed understanding of the provisions. It must be noted that the IACHR is competent to examine petitions in which violations are alleged based on any of the Inter-American Human Rights Treaties. Some of these are Inter-American Convention to Prevent and Punish Torture of 1985, Inter-American Convention on the Prevention, Punishment and Eradication of Violence Against Women, Inter-American Convention on Forced Disappearance of Persons of the year 1994, Inter-American Convention on the Elimination of All Forms of Discrimination Against Persons with Disability of the year 1999. In this regard, it is pertinent to note that not all member states of the OAS have ratified all the treaties. Before approaching a problem question, you must first double check if the accused member state has in fact ratified the treaty which is in question. Let us now talk about the Inter-American Commission on Human Rights. The Inter-American Commission on Human Rights System, or the Inter-American Human Rights System itself, was born with the adoption of the American Declaration of the Rights and Duties of Man of the year 1948, predating the Universal Declaration of Human Rights by more than 6 months. IACHR is a principal and autonomous organ of the OAS whose mandate stems from the Charter of the OAS. The Commission is made up of 7 members, independent experts on human rights who do not represent any country and are elected by the General Assembly of the OAS. The IACHR was created in 1959 and it held its first session in 1960. In fact, by 1961, the IACHR had begun to carry out on-site visits to observe the general human rights situation in member states. Thereafter, by 1965, the IACHR was expressly authorized to examine complaints or petitions regarding specific cases of human rights violations. In fact, the IACTHR was created only with the coming into force of the latest American Convention on Human Rights. And until that time, IACHR was the sole protector of human rights in the Americas. Today, the Commission's function is to promote the observance and defense of human rights in the Americas, and it acts as a first line of defense for the victims of human rights violations. The Commission performs this function by making visits to the countries, carrying out thematic activities and initiatives, preparing reports on human rights situation in a certain country or a particular thematic issue, adopting precautionary measures or requesting provisional measures before the Inter-American Court of Human Rights, and processing and analyzing individual petitions with a view to determine the international responsibility of states for human rights violations, and issuing the recommendations that it deems to be necessary in a given situation. The individual petition system, by way of which any person, group of persons or organization may file a petition alleging a violation of human rights against one or more member states of the OAS, is the single most important recourse available to the people who are living in the Americas. Once the victim files his or her petition with the Commission preliminarily evaluates it and makes a decision to either request additional information or open the petition for processing. Thereafter, at the admissibility stage, the petition is sent to the respective state for its observations on the matter at hand. On receiving the state's observation, the Commission decides on whether the petition is admissible in fact. If found admissible, the Commission then goes on to analyze the parties' allegations and evidence that is submitted along with it. Thereafter, if the Commission finds the state responsible for human rights violations, it issues a report on the merits that includes recommendations to the states that are aimed at bringing halt to the acts that are in violation of human rights, clarifying the facts, carrying out an official investigation and imposing a sanction, making reparation for the harm caused, making changes to the law, requiring the adoption of other measures or actions by the state. However, it must be noted that before a petition is filed with the IACHR, the following requirements must have been met. That is, all remedies under domestic law must have been pursued and exhausted in accordance with generally recognized principles of international law. Further, the petition must have been lodged within a period of 6 months from the date on which the party alleging violation of his rights was notified of the final judgment. Another requirement, the subject of the petition must not be pending in any other international proceeding. The petition must contain the name, nationality, profession, domicile and signature of the person or persons of the legal representative of the entity lodging the petition. In this regard, it is also pertinent to note that foregoing provisions of A and B will not be applicable when either the domestic legislation of the state concerned does not afford due process of law for the protection of the right allegedly violated, or the party alleging violation has been denied access to the remedies under domestic law or has been prevented from exhausting them. It is also important to note that in certain serious and urgent situations, and provided that certain requirements are met, the Commission may adopt certain precautionary measures. Furthermore, in addition to the precautionary measures, there is a mechanism established in Annexure 14 of the Inter-American Convention on Forced Disappearance of Persons, which the Commission can use in cases of alleged forced disappearances with respect to the states that have ratified the said treaty. Now, there is a possibility that the state decides not to comply with the recommendations of the Commission. In this scenario, where the Commission decides to either publish the case or refer the matter to the IA Court HR if it considers appropriate. The functioning of the court is discussed in the next segment that we shall be talking about. Now, let us discuss the Inter-American Court of Human Rights. Inter-American Court of Human Rights is also an autonomous judicial organ of the OAS whose mandate stems from the American Convention. The court is headquartered in the city of San Jose, Costa Rica, and is made up of 7 judges elected in their personal capacity who are from the OAS members. The objective of the court is to interpret and apply the American Convention and other American human rights treaties, in particular by issuing judgments on cases and by issuing consultative opinions. It is important to note, however, that only the state parties to the American Convention who have accepted this court's contentious jurisdiction and the Commission may submit a case to the court. Individuals in their private capacity do not have direct recourse to the Inter-American Court. They must first submit their petition to the Commission and go through the procedure for cases before the Commission. It is also important to note that the Commission may, when the conditions are met, refer cases to the Inter-American Court on Human Rights only with respect to those states that have ratified the American Convention and have previously recognized the contentious jurisdiction of the court, unless a state accepts the jurisdiction expressly for a specific case in a matter. If the court finds that there has been a violation of a right or freedom protected, the court shall rule that the injured party be ensured the enjoyment of his right or freedom that was violated. It shall also rule, if appropriate, that the consequences of the measure or situation that constituted the breach of such right or freedom be remedied and that fair compensation be paid to the injured party. Also, in cases of extreme gravity and urgency, and when necessary to avoid irreparable damage to persons, the court has the power to adopt such provisional measures as it deems pertinent in the matter it has under its consideration. It must also be noted that member states of the OAS may consult the court regarding the interpretation of conventions or any treaties within the Americas. The court accordingly may provide that state with opinions regarding the compatibility of any of its domestic laws with any of the aforesaid international instruments. Let us now discuss about some landmark judgments that have been given by the Inter-American Court of Human Rights. The Inter-American Court of Human Rights has been an active defender of human rights in the Americas. In fact, it had an impact all over the world for its innovative approach to human rights. In about one half of the rulings it has issued since it started doing its work, the Inter-American Court of Human Rights has issued orders that require action by national courts. It has also increasingly taken on a role of reviewing whether national practices of judicial independence and due process comply with the American Convention on Human Rights. Therefore, any discussion on the sources of international human rights law is incomplete without taking a look at some of these judgments in a brief manner. We shall first look at the case of Mayagna versus Avas Tingni Community, Nicaragua, that was decided by this court on August 31, 2001. The Inter-American Commission of Human Rights presented this case for the court to decide whether the state of Nicaragua violated Articles 1, that is, obligation to respect rights, Article 2, domestic legal effects, Article 21, right to property, and Article 25, right to judicial protecting of the Convention, in view of the fact that Nicaragua had not demarcated the communal lands of the Avas Tingni community, nor had the state adopted effective measures to ensure the property rights of the community to its ancestral lands and natural resources, and also because it had granted a great concession on community lands without the assent of the community. And the state did not ensure an effective remedy in response to the community's protest regarding its property rights. The Inter-American Court of Human Rights handed down a judgment affirming the existence of indigenous peoples' collective rights to their land, resources, and environment. In spite of having any real property title deed in the land it claims, the court declared that the community's right to property and judicial protection had been violated by the Nicaraguan government when the government granted concessions to a company to log on the community's traditional land without even consulting the community, let alone obtaining its consent for the same. Demeaning Nicaragua's legal protections for indigenous lands illusionary and ineffective, the court ruled that not only did the government discriminate against the community by denying them equal protection under the laws of the state, it also violated its obligations under international law to bring its domestic laws in line with the rights and duties articulated in the American Convention on Human Rights, of which Nicaragua is a signatory. In its ruling, the court declared that for indigenous communities, the relationship with land is not merely a question of possession and production. The land is also a material and spiritual element which they should fully enjoy, as well as a means of preserving their cultural heritage and passing it on to their future generations. The court finally ordered that the government of Nicaragua must demarcate the land, recognizing the community's ancestral and historical title to it, and to establish legal procedures for the demarcation and titling of the traditional lands of all indigenous communities in Nicaragua. Next is the case of expelled Dominicans and Haitians versus Dominican Republic, decided on August 28, 2014. The Commission submitted to this court against the state of the Dominican Republic. This case related to the arbitrary detention and summary expulsion by the Dominican Republic within its territory of the victims who were Haitians and Dominicans of Haitian descent, including children. Among other facts, one was also that there were a series of obstacles that had prevented Haitian immigrants from registering their children born in Dominican territory and persons of Haitian descent born in the Dominican Republic from obtaining the Dominican nationality. Among other things, the Inter-American Court of Human Rights unanimously held that the state violated 1. The rights to recognition of juridical personality, to nationality, and to a name recognized in Articles 3, 20, and 18 of the American Convention on Human Rights, as well as the right to identity owing to the said violations taken as a whole in relation to the obligation to respect rights without discrimination established under Article 1 of the Convention. 2. The prohibition of the collective expulsion of aliens established in Article 22, Clause 9 of the American Convention on Human Rights for failure to comply with the obligation to respect rights without discrimination established under Article 1 of the Convention. Third, the right to protection of the family recognized in Article 17 of this particular convention. So in this module, we discussed two cases that have been decided by the Inter-American Court of Human Rights. In the next module, we shall be continue discussing certain other important and landmark judgments that have been given by the Inter-American Court of Human Rights. Thank you for listening to this module.